In this case, at least on the face, there appears to have been some question as to the ability to place the individuals in compliance with the statute. We know that if they move in without the temporary restraining order at this juncture, it doesn't, well, strike that, I'm not phrasing this correctly. If they don't move in, it doesn't appear there's going to be a great deal of harm or damage. It appears it's been going on for a period of time where there's been other placement pending, finding them a locale, which should obviously be done under current laws. The question is where. So I don't see any particular damages that would be caused by granting just the temporary restraining order. There are some relevant matters in terms of the procedure which might have been filed for placement in Kenosha County. And I think the equities, at least at this stage, favor the plaintiff, at least for the TRO, which the court is going to grant. However, and that's because it's my belief that the placement in the county is an approval and not per se an order. The order is the supervised release aspect. And if it were just that, or if the order specifically said, I order Kenosha County and I want the department to place them there no matter what, then I agree wholeheartedly with you. I don't have the authority, I'm not a court of appeals, to overturn another judge's order. But I do believe this, my temporary restraining order prevents you from getting in trouble as contempt, because it has to be a willful knowing violation of a court order, and I think if another judge, rightfully or wrongfully, is saying at least a temporary restraining order is in effect, you can't be willfully violating the other judge's order. That'd be my position. I hope it's correct. Okay. But in that regard, I'm going to set this on for an injunction hearing, which is a whole different can of worms. And I do want the parties to look at the issues I raised. There is a serious concern of my ability, if that is an order, to tell another circuit court judge, you can't do it. I've never taken the position one circuit court judge has more authority than another circuit court judge, and I believe that's the case law, and we ran into that in Act 10 and some other things that went up on appeal and what have you. If that's a correct assessment then, and they're not there, then I think the remedy is appeal in front of the other judges, because it is a civil matter. Procedures weren't followed. You didn't look at the harm to the community, you didn't consider these criteria, we didn't get this done, that done, etc. But those would be out of those courts, not here. And then last but not least, outside of that, there was a question if the parties are not physically in Kenosha County, is if there's really proper venue, but I'm not raising it unless someone raises it in front of me, but it's a thought that crossed my mind. Okay. Yes, Counsel.
If I may be heard on a
Sure.
couple of points. One, to reiterate, I believe that the Racine court order is an order to place this individual at the secure facility designated in the plan, which is this particular address. I guess to the extent the sheriff of Racine County has not been restrained, I don't know where we're at if the sheriff shows up with this individual on Thursday.
I can only restrain those individuals who are in the case. That's all I can tell you.
I appreciate that, but I believe, again, it places us in a position where we will be forced to be in contempt of one court or the other. But
I understand your position. I seriously, if Judge Torhorst, for example, tomorrow says, yes, that is my order, and you're following his order, and you're caught between a rock and a hard place, I doubt if I'm imposing those type of penalties. I don't believe it's an order, though. That's my thought process. The order is you get out. You're now with the department developing a plan, and I can approve parts of your plan. I'm not sure I'm actually, well, I understand what you're saying.
yeah,
But at least until next week, I'm going to do the temporary restraining order to those parties obviously in the lawsuit. And you can prepare that, and that's being ordered there on the phone. We'll set a date next week. If the judges change their mind, it's moot. We don't have to worry about it. If they don't, then all those issues you're bringing up is a serious question. I do agree. If that is an order of Judge Torhorst or whoever judge has in Milwaukee, I don't think I, as a circuit judge, can tell them who your order. I'm just gonna overrule it. That's a Court of Appeals. You might have to go on up on that. But in any event, let's look at a date next week. You said both hearings, from what we're aware, tomorrow and Thursday, so we don't have to worry about that. So let's put ours, probably, clerk, I would say Wednesday, maybe afternoon, if that's convenient to the parties.
Wednesday at 1:30.